mortgages. We think we know them buying a house, right?
Yeah.
But dig a little deeper, and there's this whole complex history.
Oh, absolutely. Twists and turns you wouldn't expect.
And that's what we're doing today. We're diving deep, aiming to really nail down the key mortgage concepts, especially if you've got exams coming up.
Exactly.
Yeah.
So our focus today is mortgages, how they're created, how the mortgager is protected, and what rights the lender, the mortgagee, actually has.
Right. And we're drawing on some pretty solid sources, yeah. University-level property law materials.
That's right. We've come through them for the really vital bits. The mission, if you like, is to pull out the absolute must-knows on creation, mortgager protection, and mortgagee rights.
And we'll be repeating key terms that's deliberate to help things stick.
Definitely. Repetition is key for memory, especially for exams.
Okay, ground zero. What exactly is a mortgage, in simple terms?
Okay, fundamentally, a mortgage is the conveyance of an interest in property as security for a debt. Let's just pause on that. A mortgage is the conveyance of an interest in property as security for a debt.
So you're using the property itself to guarantee the loan, basically.
Precisely. It's the legal tool that lets someone borrow money, usually for that property,
Right.
with the property acting as the backup if things go wrong.
And the two main players. We need to be crystal clear on who's who.
Absolutely essential. First up, the mortgager. The mortgager is the borrower, the person getting the loan. Just lock that in. Mortgager, borrower.
Okay, mortgage or borrower. Got it.
Then you have the mortgagee. The mortgagee is the lender, the bank, building society, whoever is providing the cash. So mortgagee, lender.
Mortgager, borrower. Mortgagee, lender.
Right.
Now, you mentioned protection for the mortgager, the borrower. There's a really important concept here.
Yes, hugely important. It's called the equity of redemption.
Equity of redemption. Okay, what does that mean?
The equity of redemption is essentially the mortgager's remaining interest in the property once the debt is all paid off. Let's say that again. The equity of redemption is the mortgager's interest after the debt is paid.
So it's like the homeowner's actual stake in the property value.
Exactly. It represents their ownership value, clear the debt.
Yep.
And crucially, this equity redemption gives the mortgager the fundamental right to redeem the mortgage, pay it off, and get the property back, free from the lender's claim. It's a cornerstone of borrower protection in law.
That makes sense. A really vital safety net. Okay, let's move into our first big topic, creating mortgages. How do they actually come into existence legally?
Right. So creation. It helps to quickly look back before we hit the current rules. Under the old 1925 legislation, you could create a legal mortgage a couple of ways.
How did that work?
Well, one was like granting a really long lease called the demise for a term of years, absolute. The other, and this term is still relevant contextually, was a charge by deed expressed to be by way of legal mortgage.
A charge by deed expressed to be by way of legal mortgage. Quite a mouthful.
It is, but that was the historical approach, just for comparison, really.
So fast forward to today. Registered land. How's it done now?
Okay, the big player now for registered land is the Land Registration Act 2002. Remember that. The Land Registration Act 2002.
LRA 2002. Got it.
Under the LRA 2002, you create a legal mortgage using a specific method called a charge by way of legal mortgage.
A charge by way of legal mortgage.
Yes, and this needs to be in a formal document, a deed. That's required by Section 52 of the Law of Property Act 1925 and also Section 1 of the Law of Property Miscellaneous Provisions Act 1989. So a deed is essential.
But just having the deed isn't enough, is it?
No, absolutely not. This is critical. The charge by way of legal mortgage must then be registered. It needs to be entered in the charges register for that specific property title.
And which bit of law says that?
That's Section 27 of the Land Registration Act 2002. Let's repeat that. Registration is required by Section 27 LRA 2002.
Section 27 LRA 2002.
And it's only when that registration happens that the mortgage actually becomes legal. The legal rights only kick in upon registration.
Okay, so registration is key. Who actually has the power to create one of these legal mortgages on registered land?
Good question. Section 24 of the Land Registration Act 2002 covers this. It's usually the registered proprietor, the owner on the title, but it could also be someone entitled to be registered or even the owner just before the land was registered for the first time.
Right. What happens if these steps aren't followed, if it's not a proper legal mortgage?
Then you're likely looking at an equitable mortgage. Equitable mortgages are sort of the next best thing. They include mortgages of registered land that, for whatever reason, haven't made it onto the register.
Okay. Any other types?
Yes, they also cover mortgages over equitable interests in land. Think of things like a beneficiary's interest under a trust, like a life interest, or maybe a share as a tenant in common. So equitable mortgages cover both those unregistered ones on registered land and mortgages over equitable interests themselves.
And how do you create one of those? Let's start with a mortgage of an equitable interest.
For an equitable mortgage of an equitable interest, the law requires it to be done by a conveyance that's in writing and signed by the mortgager or their authorized agent.
Signed writing. Which law specifies that?
That's Section 53, subsection 1 of the Law of Property Act 1925. Let's repeat. Section 53(1) LPA 1925 requires signed writing.
Section 53(1) LPA 1925. Okay, what about those less formal attempts at mortgaging a legal interest?
Ah, yes. Sometimes people try to create a mortgage informally over a legal estate. If it doesn't meet the deed and registration rules, it might still be recognized in equity as a contract for a mortgage.
A contract for a mortgage.
Yes, but only if it satisfies the requirements of Section 2 of the Law of Property, Miscellaneous Provisions Act 1989.
Which means?
Which means it has to be in writing, contain all the terms, and be signed by both parties. That's Section 2 LPA, MPA 1989. Let's say that again. Section 2 LPA 1989. If you have a valid contract like that, equity might step in and treat it as an equitable mortgage.
Okay. What about the old idea of just handing over the deeds? Does that still work?
Good point. That's the equitable mortgage by deposit of title deeds. Historically, just depositing the deeds with the lender as security could create an equitable mortgage.
But not anymore.
Not quite on its own. Since Section 2 LPA 1989 came in, the mere deposit isn't enough. You still need that written contract that complies with Section 2 MPA 1989.
So the writing requirement is crucial now.
Absolutely. The case that really cemented this was United Bank of Kuwait v. Sahib in 1997. Let's repeat that case. United Bank of Kuwait v. Sahib. It confirmed the need for the written contract under Section 2.
United Bank of Kuwait v. Sahib.
Right.
And an equitable charge. How's that different?
An equitable charge is a bit simpler. It's where a property is basically earmarked or appropriated to pay off a debt. There's no actual transfer of an interest like with a mortgage. It's just an agreement that this property stands as security. An equitable charge. Property appropriated to discharge a debt.
Okay. Let's just quickly go back to registered land under the LRA 2002. What happens if someone creates a mortgage but doesn't register it?
Right. Under the LRA 2002, sections 25 to 27 make it clear. If you have a mortgage of registered land, but it's not registered in the charges register, it operates only in equity. It's an equitable mortgage.
But it can become legal.
Yes, if it's then substantively registered. Once registered, Section 51 of the LRA 2002 says it takes effect as a legal charge, regardless of how it started. So unregistered ones are equitable under SS.2527 LRA 2002 until registered. Then they become legal charges under S.51 LRA 2002.
Okay, clear. Now what about the flip side? Unregistered land, land that isn't on the land register yet.
Right. For unregistered land, the initial creation still uses those older 1925 methods, the demise or the charge by deed.
Oh.
But there's a massive catch now.
Oh, what's that?
Creating the first legal mortgage over unregistered land now triggers compulsory first registration of the land title itself.
Ah, so it forces the land onto the register.
Exactly. Under Section 4, subsection 1 of the Land Registration Act 2002, creating that first legal mortgage means you have to apply to register both the land and the mortgage. Let's repeat that trigger. Section 4.1 LRA 2002.
Section 4.1 LRA 2002, compulsory registration. But what if the land stays unregistered for some reason? How do you protect mortgages then?
If the land somehow remains unregistered, certain types of mortgages need to be protected by registering them as land charges under a different system, the Land Charges Act 1972.
Okay, what gets registered there?
A PRESA mortgage, that's a legal mortgage where the lender doesn't hold the title deeds, is registered as a Class CI land charge. Remember that?
Yeah.
Class CI land charge.
Okay.
A contract to create a legal mortgage, we mentioned that earlier, and a state contract that goes down as a Class CIV land charge. So contract for a mortgage, Class CIV land charge.
Got it. And a general equitable charge, the kind we discussed where property is just appropriated, is registered as a Class C3 land charge. That's specified in Section 2, subsection 4 of the Land Charges Act 1972. So, general equitable charge, Class C3 land charge under Section 2.4 LCA 1972.
C3, Section 2.4, LCA 1972.
Right.
What about the equitable mortgage where the lender does hold the deeds?
Generally, that type, the one protected by deposit of deeds, isn't registrable under the Land Charges Act. It doesn't fall into Class C3 or Class C. Its protection comes from holding the deeds.
Okay. And one last thing on creation priorities between competing equitable mortgages over equitable interests. Is there a rule for that?
Yes, there is. The priority there is usually determined by the rule in Dearl v. Hall, a very old case from 1828. Let's repeat that. The rule in Dearl v. Hall, 1828.
Dearl v. Hall, 1828.
Broadly, it means the first equitable mortgagee to give notice of their mortgage to the trustees who hold the legal title usually gets priority.
Okay, so boiling down this whole creation section, especially for registered land under the LRA 2002, what's the absolute key takeaway? The absolute non-negotiable under the LRA 2002 for registered land is that substantive registration under Section 27. Subsection 2 is vital. Let's stress that.
Yeah.
Section 27.2 LRA 2002. Without that registration, it's not a legal charge. It stays equitable. That registration step is everything for legal status.
Section 27.2. Crystal clear.
Yeah.
Right. That's creation covered. Let's switch gears to our second area, protecting the mortgager's equity of redemption.
Yes, this is where equity really steps in to shield the borrower. There's this core idea about clogs and fetters.
Clogs and fetters. Sounds medieval.
Yeah, it does a bit. But it basically means anything the lender tries to put in the mortgage deal that unfairly restricts or prevents the borrower's right to redeem their right to pay off the debt and get the property back clean. Equity says these clogs and fetters are void.
So the lender can't just put any old condition in there to stop you getting the property back.
Exactly. Equity protects that fundamental right to redeem.
Can you give an example of a clog?
A classic one is where the mortgage includes an option for the mortgagee, the lender, to buy the property.
Ah, so the lender could force a sale to themselves.
Well, the general rule is that such an option within the mortgage itself is void. It's seen as unfairly taking advantage of the borrower's situation. The big case here is Samuel v. Jarrah Timber and Wood Paving Corp. Ltd. from 1904. Let's repeat, Samuel v. Jarrah Timber. Giving the lender an option to buy is usually a clog.
Samuel v. Jarrah Timber. Okay. Are there any circumstances where an option to purchase might be okay?
Yes, potentially. If the option to purchase is genuinely a separate deal, negotiated freely after the mortgage is already set up, then it might be upheld. It can't be part of the original mortgage bargain itself.
So timing and independence are key.
Absolutely. The case Re v. Lyle from 1902 is a good example of where a later separate option was allowed. So remember Re v. Lyle for that distinction?
Re v. Lyle. Okay. Have there been more recent cases on this?
Yes, it still comes up. In Jones v. Morgan in 2001, the Court of Appeal looked at an agreement giving the lender an option to buy a share in the land. The majority said no, it was part of the mortgage, a clog, and void. Let's repeat. Jones v. Morgan, 2001.
Jones v. Morgan, 2001.
Although, interestingly, there was a dissenting judge, Lord Phillips, who thought it could be seen as separate. It shows it can still be debatable.
And what about the Warnborough v. Garmite case? How did that fit in?
Warnborough v. Garmite from 2003. There, the court said you have to look at the substance of the whole transaction. Just because an option is in the same document or signed at the same time doesn't automatically make it a clog. You need to figure out the true nature of the deal. So, Warnborough v. Garmite 2003 emphasizes looking at the real bargain.
Warnborough v. Garmite 2003. Substance over form. Okay. Another way to effect redemption is delaying when the borrower can actually pay off the loan, right?
Yes, postponing the contractual date for redemption. Now, it's normal to have some period before redemption is allowed the lender needs to earn interest, but the postponement can't be so long or unreasonable that it basically makes the equity of redemption meaningless.
So it can't be postponed forever or practically forever?
Exactly. It can't make the right to get the property back an illusion.
There are a couple of key cases that show this contrast, aren't there?
Yes, perfect examples. First, Fairclough v. Swan Brewery from 1912. The mortgage was on a lease, and they said it couldn't be redeemed until just 6 weeks before the lease ended. The court said that was void. It made the redemption worthless. So Fairclough v. Swan Brewery, 1912.
Fairclough v. Swan Brewery, 1912. Makes sense. What's the contrasting case?
That's Knightsbridge Estates Trust v. Byrne from 1939. This involved a commercial mortgage on a freehold property between two businesses. The redemption was postponed for 40 years.
40 years, and that was okay.
It was upheld. The court reasoned they were commercial parties, bargaining freely, and it was a long-lasting freehold property, not a diminishing lease. So Knightsbridge Estates Trust v. Byrne, 1939, shows postponement can be okay in commercial contexts.
Knightsbridge Estates v. Byrne, 1939. Interesting contrast. Now, beyond these equity rules, is there legislation protecting borrowers?
Oh yes, quite a bit. For residential mortgages, the Financial Conduct Authority, FCA, is a major regulator under the Financial Services and Markets Act 2000, or FSMA. Remember FSMA 2000?
FSMA 2000, FCA regulation. What about other mortgages?
Historically, the Consumer Credit Act 1974 was very important, especially as amended by the Consumer Credit Act 2006. Let's repeat those. Consumer Credit Act 1974 and Consumer Credit Act 2006. These acts aim to protect consumers in credit agreements, including some mortgages.
So the FCA's role has expanded now, hasn't it?
Yes, the regulatory landscape has shifted, with the FCA now covering more types of mortgages, aiming for more consistency.
Can you give an example of how the Consumer Credit Acts helped borrowers?
Sure. Under the 1974 Act, courts could reopen extortionate credit bargains. A good example is Falco Finance v. Gulf from 1998. A mortgage had this nasty dual interest rate that jumped up massively if you fell into arrears. The court said that was extortionate. Remember Falco Finance v. Go, 1998?
Falco Finance v. Go, 1998, extortionate bargains. And the 2006 Act brought in something new.
It did. The Consumer Credit Act 2006 introduced the idea of an unfair relationship between the lender and borrower. This is broader than just looking at extortionate terms.
Unfair relationship, how does that work?
The court looks at the whole picture, the terms, how the lender behaved, everything to see if the relationship itself is unfair to the borrower. The recent Supreme Court case, Smith v. Royal Bank of Scotland Plaque 2023, gave more guidance on this. So, Smith v. Royal Bank of Scotland 2023 is key for unfair relationships.
Smith v. Royal Bank of Scotland, 2023. Okay. Are there general consumer protection rules that apply to?
Yes. The Unfair Terms in Consumer Contracts Regulations 1999, often called UTCCR 1999. These can catch unfair terms in mortgages if they create a significant imbalance against the consumer. Let's repeat. Unfair Terms in Consumer Contracts Regulations 1999.
UTCCR 1999.
And interestingly, that same Falco Finance v. Gauck case also found the dual interest rate unfair under these regulations too, so it fell foul both tests.
Right. Sometimes mortgages include extra perks for the lender beyond just getting the loan repaid. How does the law view those?
These are called collateral advantages. Think of, say, a pub owner getting a mortgage from a brewery and having to agree to only buy that brewery's beer a tie.
Are those allowed?
Generally, yes, provided they aren't unconscionable, don't unreasonably restrain trade, and crucially, they're designed to end when the mortgage is redeemed.
So they shouldn't linger after the debt is paid.
Traditionally, no. But the case of Kregliner suggests courts might be more willing now to uphold advantages that continue after redemption if they are genuinely independent commercial agreements, not just part of the security. So Kregliner hints at more flexibility.
Kreglinger. But purely permanent restrictions are still usually out.
Yes, permanent fetters on the property after redemption are generally void. The case for that is Noakes v. Rice from 1902. Remember, Noakes v. Rice for invalid permanent fetters.
Noakes v. Rice. Okay. And you mentioned restraint of trade with those tie clauses.
Exactly. Those solus ties, like the pub example, are looked at under the doctrine of restraint of trade. The court asks if the restriction is reasonable between the parties and for the public. The key case is Esso Petroleum v. Harper's Garage from 1968. Let's repeat. Esso Petroleum v. Harper's Garage, 1968. The length of the tie is often crucial.
Esso Petroleum v. Harper's Garage, 1968.
Right.
Finally, on protection, do courts just have a general power to step in if a mortgage term seems really unfair?
They do have a limited inherent equitable power to strike down terms that are truly oppressive or unconscionable. But honestly, they use this power very sparingly.
Why is that?
Especially in commercial deals, courts assume parties know what they're doing. Just being a bad bargain or unreasonable isn't usually enough. You typically need to show the stronger party acted badly, maybe exploiting a weakness.
So it needs to be morally wrong, not just tough.
Pretty much. The cases of City Land and Property v. Debra from 1968 and Multi-Service Bookbinding v. Martin from 1979 illustrate this. They show courts are reluctant unless there's real sharp practice. Remember those cases? City Land and Property v. Debra in 1968 and Multi-Service Bookbinding v. Martin 1979.
City Land v. Debra, 1968, and Multi-Service Bookbinding v. Martin, 1979. High bar for unconscionability. Okay, that's a great overview of borrower protection. Let's tackle our final section, the rights of the mortgagee, the lender.
Right. The lender obviously needs rights too. The most basic is the right to sue the borrower personally for the debt if they don't pay.
But the really powerful rights relate to the property itself, the security.
Exactly. The main enforcement rights are the power of sale and, much less common now, foreclosure. We should really focus on the power of sale.
Okay, power of sale. When does the lender actually get this power?
If the mortgage was made by deed, which legal mortgages almost always are, the statutory power of sale arises as soon as the mortgage money becomes due according to the contract. This is under Section 101 of the Law of Property Act, 1925, key section. Section 101 LPA, 1925.
Section 101 LPA 1925. So the power exists once payment is technically due. But they can't just sell straight away, can they?
No, absolutely not. That's crucial. The power arising under Section 101 is one thing, but it only becomes exercisable when certain conditions in Section 103 of the Law of Property Act 1925 are met.
Section 103, what are those conditions?
There are three main ones. First, the lender serves notice demanding repayment, and the borrower defaults for 3 months after the notice. Second, some interest is overdue by at least 2 months. Or third, the borrower has broken some other condition in the mortgage deed. Only then is the power exercisable under Section 103 LPA 1925.
Section 103 LPA 1925. So power arises S101, exercisable S103. Got it. When they do sell, what duties do they owe the borrower?
2 main duties. First, they have to act in good faith, no dodgy motives. Second, they must take reasonable care to get the true market value, or the best price reasonably obtainable at the time of sale.
Reasonable care for the best price. Is there a key case for that?
Yes, the famous one is Cuckmere Brick Co. v. Mutual Finance from 1971. The lender failed to mention planning permission when selling, which lowered the price. They were held liable. So Cuckmere Brick Co. establishes that duty.
Cuckmere Brick Co. And you mentioned best price reasonably obtainable.
Yes, that phrasing comes from cases like Sylvan Properties from 2003. It clarifies the standard. They don't have to wait forever for the market to improve, but they must get the best price possible at that time. Remember, Sylvan Properties.
Sylvan Properties, okay. Can the lender sell the property to themselves or someone connected to them?
They can, but it's looked at very suspiciously by the courts. If they sell to a connected person or company, the burden is on the lender to prove they acted totally fairly and still got the best price reasonably obtainable.
So it raises a red flag.
Definitely. The case of Saquon Lam v. Wong Chit Sen from 1983 is the authority here. Remember Saquon Lam for sales to connected parties.
Saquon Lam. Can the borrower do anything to influence the sale? Maybe try to sell it themselves?
Yes. The borrower can apply to court under Section 91, subsection 2 of the Law of Property Act 1925. They can ask the court to let them handle the sale or make other directions.
Section 91-2 LPA 1925.
Exactly. The court might allow it if it seems fair, perhaps if the borrower can likely get a better price. The case POC v. Mortgages Service Funding from 1993 is a good example. So Section 91-2 LPA 1925 and POC v. Mortgages Service Funding.
POC v. Mortgages Service Funding. Okay. When the lender sells, what happens to other people with interests in the property, like a second mortgage?
The sale by the mortgage wipes out their own mortgage and any mortgages or interests created after theirs. The buyer takes the property free from those.
But what about interest created before the lender's mortgage?
The buyer takes the property subject to those prior interests. They remain attached to the land.
Okay. And the money from the sale, what happens to that?
The lender holds the sale money on trust. They have to distribute it in a strict order set out in Section 105 of the Law of Property Act 1925.
Section 105 LTA 1925. What's the order?
First, pay off any mortgages that had priority over theirs. Second, cover their own costs of the sale. Third, pay off their own mortgage debt, principal and interest. And finally, if there's anything left over the surplus, it goes back to the mortgager. That's Section 105 LPA 1925.
Section 105. Very clear steps. You mentioned foreclosure earlier being rare. Just briefly, why?
Foreclosure is where the court basically ends the borrower's equity of redemption entirely and just gives the property to the lender. It's rare because it's seen as potentially unfair. The lender might get a property worth much more than the debt. Courts almost always prefer ordering a sale under Section 91-2 instead, as it ensures any surplus goes back to the borrower.
Right, sale is fairer. Now, the lender also has a right to take possession, don't they?
Yes, a legal mortgagee technically has the right to possess the property from day one. The famous quote from Four Maids Ltd v. Dudley Marshall in 1957 is that the right arises before the ink is dry on the mortgage. Remember, Four Maids Ltd.
Four Maids Ltd. But they don't usually take possession straight away.
No. Usually, they only seek possession if the borrower defaults, typically as a step towards selling the property with vacant possession, which usually gets a better price.
If they do take possession, what are their responsibilities?
They have a very strict duty to account to the borrower, not just for the rent they actually get, but for the rent they could have got if they'd managed the property properly. It's called accounting on the basis of willful default.
Willful default. Is there a case for that?
Yes, White v. City of London Brewery from 1889. So remember White v. City of London Brewery for the strict accounting duty.
White v. City of London Brewery, can the borrower stop the lender taking possession?
Well, the court has an old inherent power to pause possession proceedings briefly if the borrower has a realistic chance of paying off the entire mortgage debt quite soon. That's from Birmingham Citizens Permanent Building Society v. Kant in 1962. Let's repeat. Birmingham Citizens Permanent Building Society v. Kant.
Birmingham Citizens v. Kent. But that's paying off the whole lot.
Yes, the inherent power is quite limited. But for residential properties, there's much stronger statutory protection.
This is where those other acts come in.
Exactly. Section 36 of the Administration of Justice Act 1970, that's AJA 1970, and Section 8 of the Administration of Justice Act 1973, AJA 1973. These give the court power to suspend or postpone a possession order for a dwelling house.
Section 36, AJA 1970, and Section 8, AJA 1973. On what grounds?
If it looks like the borrower can likely pay any sums, due typically the arrears, plus ongoing payments within a reasonable period.
And what counts as a reasonable period?
That was considered in Cheltenham and Gloucester BS v. Norgan in 1996. The Court of Appeal said a reasonable period could potentially be the entire remaining term of the mortgage, so it gives borrowers significant breathing space. Remember Cheltenham and Gloucester BS v. Norgan.
C&G v. Norgan. That's a big protection. What if the lender just tries to take possession without going to court?
Technically, the common law right allows that, as explored in Ropajilic v. Barclays Bank in 2000. Remember Ropajilic v. Barclays Bank 2000? But firstly, using or threatening violence to enter against someone who's actually there and objecting is a criminal offense under the Criminal Law Act 1977. And secondly, crucially, if they don't go to court, the borrower loses the protection of Section 36 AJA 1970 because that section only applies to court proceedings. So peaceful repossession without a court order sidesteps that key statutory safeguard. Right, so going to court triggers the Section 36 protection. Yeah. Okay, one last right. Appointing a receiver. Yes. The lender often has the power to appoint a receiver to manage the property instead of taking possession themselves. This power usually arises under Section 101 LPA 1925 and becomes exercisable under Section 103 LPA 1925, just like the power of sale.
Sections 101 and 103 again.
Exactly. The receiver, although appointed by the lender, is legally considered the agent of the borrower. They collect income, pay expenses, pay the mortgage interest, and potentially the capital, according to rules in Section 109 of the Law of Property Act 1925. Remember Section 109 LPA 1925 for the receiver's duties with the money?
Section 109 LPA 1925. Okay, I think that covers the main rights. So pulling it all together, we've covered how mortgages are created legal versus equitable and that crucial role of registration under the LRA 2002. Then we looked at protecting the borrower's equity of redemption, fighting off clogs and fetters using statutory help like the Consumer Credit Acts and AJA 197073, and tackling unfair terms.
And finally, the lender's rights, primarily the power of sale governed by LPA 1925 sections 101, 103, 105, the right to possession, and the limits on it, and appointing a receiver under Section 109 LPA 1925.
Remembering all that key legislation, LPA 1925, LRA 2002, CCA 1974-2006, AJA 1970-1 and 73, and the landmark cases like Samuel v. Jarrah Timber, Cuckmere Brick, C&G v. Norgan is really going to be vital.
Absolutely. Having those reference points clear is essential for understanding how this area works, especially for any exams.
Definitely. So as you mull all this over, here's something to think about. How has that balance of power between the borrower and the lender shifted over time? We've seen equity step in, then statutes. What does that mean for today's housing market with ongoing debates about protecting borrowers versus ensuring lenders feel secure?
That's a great point. It's a constantly evolving dynamic, isn't it? Worth reflecting on.